The Supreme Court just dropped an emergency order so explosive it could effectively end the gun permit system as we know it in America. And here's the part nobody saw coming. The Department of Justice isn't just standing on the sidelines. They've stepped onto the battlefield, and for the first time in history, the U.S. Solicitor General will argue against a state permit system in front of the 9 justices. Right now, 26 states have lined up on one side of this constitutional showdown. On the other side, a handful of states like Hawaii, New York, and California are scrambling in full panic mode to save their most restrictive carry laws. This isn't just another court case. This is the ultimate showdown over where your rights begin and where government permission ends. And what happens in the next 60 days will permanently reshape how 100 million gun owners exercise their rights across America. This case moved with terrifying speed. If you've been watching the fallout from the Bruen decision in 2022, you know that the Supreme Court told states they couldn't just deny permits because they felt like it. The court established a new test for all gun regulations. Any restriction on the Second Amendment must have a historical analog from America's founding era. If similar laws didn't exist when the Constitution was ratified, modern versions can't stand. States had 2 choices: accept the new reality or find creative ways around it. Most chose option 2. Between June 2022 and January 2025, 8 states passed a combined 63 new firearm restrictions. California led with 19 separate laws. New York followed with 16. They weren't scaling back, they were doubling down, and the Supreme Court noticed. But what happened next was a masterclass in government subterfuge that triggered this emergency ruling. To understand why the Supreme Court had to step in with emergency-level focus, you have to look at what Hawaii tried to pull. After Bruen, Hawaii didn't expand carry rights. They inverted them. They passed a law that turned 99.8% of the state into a no-carry zone by default. Under Hawaii's new rule, even if you have a state-issued permit, you are automatically breaking the law if you step onto any private property open to the public. Think gas stations, grocery stores, or malls. Unless that owner has posted a sign or given you explicit written permission first. It's been dubbed the vampire rule because, like a vampire, you need an invitation to enter. But here's the trap. Hawaii's own lawmakers admitted in leaked emails that they knew most businesses wouldn't bother putting up guns welcome signs. The goal wasn't to protect property rights. The goal was to make your permit useless the moment you leave your driveway. This is what finally pushed the court to act. The case that brought this to a head started in Maryland with a man named Christopher Holdren, a retired law enforcement officer who applied for a concealed carry permit in 2023. He passed every requirement: clean background, training completed, fees paid. Maryland denied him anyway. Not because he was dangerous, because he didn't prove sufficient need. Even after Bruen, Maryland kept operating like the old rules still applied. Holdren sued. Lower courts sided with Maryland. Then the Supreme Court stepped in with an emergency stay that froze Maryland's entire permit system. That was 3 weeks ago. Today, the implications are spreading like wildfire. But there's one decision the court made that changed everything about this case. On February 28, 2025, something extraordinary happened. The Supreme Court formally invited the U.S. Solicitor General to present oral arguments, not on behalf of Maryland, on behalf of Holdren and the challengers. Let that sink in. The federal government's top Supreme Court lawyer will argue against a state permit system in front of the 9 justices. The Solicitor General's office filed a 47-page brief that systematically dismantled every argument permit states have made since Bruen. They examined colonial laws, founding-era statutes, and Reconstruction regulations. Their conclusion? No historical precedent exists for requiring government permission before exercising the right to bear arms. The brief used devastating language. It called permit systems incompatible with the text and history of the Second Amendment. It described fee requirements as poll taxes on constitutional rights. But here's where it gets even more shocking. The DOJ used a specific legal word 4 times in their brief: pretextual. In plain English, they called Hawaii a liar. The DOJ argued that Hawaii is using property rights as a pretext to suffocate the Second Amendment. Think about the weight of that. The highest law enforcement agency in the country is telling the Supreme Court these states are cheating, they are trying to bypass your authority. Then came the data that shocked legal experts. The DOJ's brief included analysis showing permit systems don't correlate with public safety improvements. States without permits don't have higher gun crime than states with them. In fact, FBI statistics from 2015 to 2024 show permitless carry states experienced a 6.8% decline in violent crime, while permit-required states saw only a 1.3% decline. The numbers don't support the restrictions. When the country's chief legal office abandons permit defenses and joins the challengers, it sends a message to every federal court in America. This isn't about one case. This is about national policy. And state attorneys general started making phone calls immediately. Within 72 hours of the Supreme Court's emergency order, 26 state attorneys general filed a joint amicus brief supporting the challengers. Not 6, not 12, 26. That's more than half the country formally arguing that permit requirements violate the Constitution. This coalition is remarkable. It includes deep red states like Texas and Wyoming. It includes purple states like Arizona and Georgia. These aren't fringe activists. These are elected officials representing 176 million Americans telling the Supreme Court that permit systems have failed both legally and practically. The brief presented devastating case studies. In New Jersey, the average permit takes 287 days to process. New York charges $340 in combined fees before issuing a permit. California requires applicants to purchase liability insurance that costs $47 monthly. Maryland mandates 16 hours of training that costs between $200 and $400. Add it up. You're looking at $500 to $800 and 6 to 9 months before exercising a constitutional right. The 26 states argued this isn't regulation. It's prohibition by bureaucracy. But while the lawyers argue about the Constitution, there is a secondary explosion happening that nobody is talking about yet. Behind these permit systems is a massive multi-million-dollar money machine. And as this case moves toward a final ruling, that machine is starting to collapse in real time. Between 2022 and 2025, states like California, New York, and Illinois built a financial ecosystem worth over $200 million annually in government fees alone. Every background check, every renewal, and every administrative processing charge has been funding state budgets and IT systems. But with the Supreme Court ready to strike down these mandatory permit structures, that revenue isn't just shrinking, it's evaporating. In fiscal year 2024, California collected $52.6 million in permit-related fees. New York brought in $41.3 million. Illinois collected $31.7 million. New Jersey pulled in $28.4 million. Across all permit-required states, that's $287 million annually. That's just government revenue. The private sector dwarfs it. Mandatory training requirements created an entire industry worth an estimated $840 million nationwide. Certified instructors, shooting ranges built specifically for permit courses, insurance companies selling required liability policies, software firms providing applicant tracking systems. When permits become optional, that money vanishes. The fallout has been immediate. When Hawaii and California's permit requirements were hit with preliminary injunctions in late 2024, we saw reports of major training companies filing for bankruptcy as their customer base stopped showing up. Between November 2024 and March 2025, 5 major carry training companies filed for bankruptcy protection. The largest, National Carry Certification LLC, had 340 instructors and 19 physical locations. They're liquidating everything. In Hawaii, permit applications plummeted by 78% by February 2025. Maryland's permit processing division employed 63 staff in January 2025. By March, that dropped to 28 because applications crashed 71% after the emergency order. But the most dangerous part of this limbo isn't the money. It's the position it puts our law enforcement in. Right now, sheriffs and police chiefs are caught in an impossible legal trap. Imagine you're a patrol officer. You stop someone with a firearm. Under current state law, they need a permit. But you know, and your chief knows, that the Supreme Court is weeks away from declaring that law unconstitutional. If you arrest that person today, and the law is struck down tomorrow, you have just opened yourself and your department up to a civil rights lawsuit. On March 3, 2025, the Maryland Sheriff's Association held an emergency conference call. 17 sheriffs participated. According to leaked minutes, they discussed enforcement discretion during constitutional uncertainty. Translation, they're terrified of being on the wrong side of a Supreme Court ruling. 3 sheriffs announced they'd stop checking for permits during routine stops unless another crime was involved. In January 2025, we saw a historic joint statement from 19 California sheriffs publicly declaring they would no longer check for carry permits during routine stops. They aren't doing this to be activists. They're doing it to protect their officers from massive 6-figure settlements for wrongful prosecution. Prosecutors made even faster calculations. Between June 2024 and early 2025, district attorneys in over a dozen counties quietly dismissed nearly 2,000 pending permit-related charges. Between the emergency order and today, prosecutors in 11 counties across Maryland, New York, and New Jersey dismissed 412 additional charges related solely to permit violations. Why drop cases? Because if the Supreme Court rules permits unconstitutional, every conviction becomes a civil rights lawsuit waiting to happen. Gun control groups are in a state of emergency. Leaked strategy calls from organizations like Giffords and Everytown show them redirecting millions of dollars away from lobbying and into litigation defense. Everytown held 3 emergency strategy sessions in the first week of March. Internal emails show them discussing post-permit advocacy frameworks and alternative regulatory strategies. That's not the language of confidence. That's the language of retreat. Giffords redirected $3.8 million from state lobbying to federal litigation support. They aren't trying to pass new laws anymore. They're fighting a desperate rearguard action to keep the laws they already have from being wiped off the books. But here's the question that should terrify every politician in a permit state. If the permits go away, what actually happens to crime rates? The anti-gun lobby has warned of blood in the streets for decades. But as 29 states have already moved to permitless carry, we now have the data. We don't have to guess. We have the shadow statistics. According to the latest FBI data, released for 2024 and early 2025, the Wild West scenario never happened. In fact, in states that transitioned to permitless carry over the last decade, violent crime didn't skyrocket. It followed national downward trends and in some cases decreased faster than in states with strict permit laws. Take Vermont, which has never required a permit in its entire history. It consistently ranks as one of the safest states in the union. Look at Maine and New Hampshire, both permitless, both with gun homicide rates far lower than the national average. Maine went permitless in 2015. 10 years later, their gun homicide rate is 1.0 per 100,000, lower than before the law changed. The data suggests a reality that permit states are desperate to ignore. Criminals don't apply for permits. By eliminating the permit maze, states aren't arming criminals. They're simply stopping the harassment of law-abiding citizens. This is the core of what's sitting before the Supreme Court right now. The court is moving toward a final roadmap where the Second Amendment is finally treated as a first-class right. Think about it. Do you need a permit to go to church? Do you need to pass a state-mandated speech training course and pay a $200 fee before you can post a video on YouTube? No, because the Supreme Court has ruled that you don't need government permission to exercise a fundamental right. During oral arguments in Bruin, Justice Thomas asked New York's Solicitor General a pointed question. How is requiring someone to demonstrate a special need before carrying a firearm different from requiring someone to demonstrate a special need before speaking freely? New York had no good answer. Neither does Maryland now. Legal historians searched for founding-era precedents supporting permit requirements. They found nothing. Colonial America had gun regulations, restrictions on firing weapons in populated areas, prohibitions for specific dangerous individuals, but never blanket requirements for government permission before carrying arms. The closest analog was an 1871 Texas law requiring handgun permits. The Texas Supreme Court struck it down the same year as unconstitutional. By the time the final ruling drops, the court is expected to make this official. The default in America is that you have the right to carry. The government can only stop you if they can prove you are a specific danger, not the other way around. So, what is the actual timeline? Oral arguments began January 20th, 2026. This is where we saw the DOJ and those 26 states face off against Hawaii and California's lawyers. Spring 2026, we expect a secondary wave of lawsuits. Already, 127 cases are paused in lower courts, waiting for the Supreme Court to give the green light to dismantle permit requirements for good. June 2026, the final decision. If the court rules as expected, the vampire rules and mandatory permission slips will be declared unconstitutional nationwide. This isn't just about guns, it's about default power. Does power start with the state or does it start with the citizen? For a century, states like Hawaii have operated on the belief that they own your rights and lease them back to you for a fee. That era is coming to a violent end in the courtrooms. The permission trap is snapping shut on the people who built it. If you want to be the first to know when the emergency ruling officially drops, you need to be subscribed. We are tracking every filing, every DOJ brief, and every sheriff's declaration in real time. This is the biggest shift in American civil rights in our lifetime. Don't get left behind. Hit subscribe, turn on notifications, and I'll see you on the next update.